Hello everyone, it's nice to have you here again. So in today's video, we'll be talking about the law of contract. We'll be looking at the definition and elements of contract, the privity, terms, exemption clauses in a contract, the vitiating element, right? And how contracts can be discharged. We'll also look at the remedies for breach of contract, and then we'll take a look at a contract. So the big question is, what is a contract? Because contract is something that we get ourselves involved in our day-to-day life. We can actually say that contract is an agreement between two or more persons which creates obligations under the law and give rise to enforceable rights. So I'm just going to point out some keynotes for us so that we can use to get this definition very well. First is an agreement. Second is like that agreement creates obligations which give rise to enforceable rights. So there will be an agreement, and then that agreement must give rise to enforceable rights. So that is when it is a contract. Okay. So the elements of contract, for a contract to be valid, there are some key things that it will have for it to be valid. And the first one is an offer. Next is acceptance, consideration, intention to create legal relations, and then capacity to enter into contract. Now I'll be explaining these key elements in a jiffy. Now, what is an offer? Okay, an offer can be likened to a proposal, right? So when a person proposes terms to another person and talks about it, that is, make communication to the effect, and if the person accepts those terms willingly and is ready to enter contract with him, then we can now say, okay, fine, an offer has been proposed, right? So most of the times this offer is definite, it is clear, right, by the person that is giving it out, and there's an intention to it. There's an intention, and that is when it is accepted, right? That's when it is accepted. So as it's stated here, it said an offer is the final proposal that transforms the offeror's promise into a contractual obligation when accepted by the offeree. So I want to point some key things here. An offer is quite different from an invitation to treat. The word says it is a final proposal. So invitation to treat is more or less like an invitation to negotiate. Okay, it's just like saying, come, let us negotiate. And when you negotiate, you've amended the offer, and then it's no longer an offer, right? So the final proposal makes it an offer. And offer is quite different from advertisement, which is an example of invitation to quit. It is quite different from auction. It is quite different from tenders. You'll find this in your study pack. It is quite different from goods on display, passenger tickets, and the rest. Now, advertisement, when you see an advert placement, you can actually then negotiate to it. When you see something that is up for auction, it is not the final proposal, it is not the final term. You can actually still negotiate your way into it. When you see goods that they display, let's say show glasses now, in the market, you can actually say, okay, fine, this thing is costing 1,000 naira, and I want to give you 500 naira for it. You see, you're actually negotiating it. It's not the final proposal. The final proposal makes it an offer, right? And then when you actually negotiate at a point, when you try to change what the proposal was, then you're actually countering that offer, right? You're actually countering the offer, because an offer must be clear, it must be final, it must be definite. So, but if there's something that's going to amend it, then it's a counter offer. So a counter offer has a dual significance. It amounts to a rejection of the offer. It destroys that offer that was made before, and it can no longer be accepted. So you will now know that, okay, this is the true significance of a counter offer. It's no longer the first proposal is no longer it again. As you're countering that first proposal, you are destroying it entirely, so it can no longer be accepted. You get? So there are also things that can make an offer to be revoked at any time before it is accepted. Let's say there's an offer, there's a proposal now towards somebody. There are things that can make it not to be revoked, right? First is when there's a death of either party, non-acceptance. But there are two key ones I highlighted here. I'm going to explain this supervening illegality, because when I was practicing a diet question, I saw this there, supervening illegality. Now the example they painted was someone paid another to import something, and unknown to them, that particular thing which they contracted was illegal in the country. So And when the goods was being shipped to Nigeria, they actually seized it. The customs officer seized it and all that. And when the customs officer seized it, the guy that the person that is importing, like the owner of the goods, right, went to ask the person he paid. I was asking of his goods, what happened. Then the other person, the party B, was trying to explain to him that, see, I tried to import the goods, but the customs seized it and all that. And then the party A sues him, he sues the party, and that's where there's an issue. Now, in the law court, the law held that um, based on the illegality, although both of them did not know about the illegality, but then based on that factor that what they were actually contracting about is illegal, therefore there is no compensation for it, and then they are not bound by any contract. That contract is revoked. Are you seeing it now? So there is a supervening illegality of that offer, which in the instance that was painted in that diet, it was unknown to both of them, right? So let's move on to acceptance now. Acceptance of an offer may be described as an assent of the offeree in terms of the offer stated by the offerer, right? So when there is an offer and it's just simple yes or in writing, because um, there are conditions to an offer being fulfilled or an offer being accepted. First is that acceptance must be plain, it must be unequivocal, it must be unconditional. You will not say okay, no, there's nothing like that, right? And there will be no variance of any kind between it and the proposal. You won't actually now want to say I'm not, no, you must be plain, right? And you must communicate it to the other party without unreasonable delay. So there must not be a delay in communicating your acceptance, right? But then when there is a conditional acceptance, I think you're not sure, you're not certain. Remember we said offer is final, right? Offer is clear and definite. When you're now being conditional about it, then it's now leading to a counter offer, right? So I highlighted here that the request for additional information, however, does not amount to a counter offer, because you can actually be not sure about it and then you just want to know more about the offer. You want to get more information. It doesn't mean you rejected it, right? It doesn't mean you rejected it, so the offer still stands, right? But the acceptance must be communicated by an external manifestation of consent, either by word said or act done by the offeree or his authorized agent. So you must actually say something. You must say yes. You must communicate it either by post, yeah. You must communicate it, I mean to say, you must communicate your acceptance. Now I actually made a statement there. I say communication by post. Now that one is when there are exceptions to the rule of communication of acceptance, right? Communication by post is communication by writing, right? Posting of letter of acceptance, and all those things. When there is just like a job offer. Now when there's a job offer, or you're proposing for something to a company and then they're accepting, they can actually draft a letter stating that they've accepted it, right? Or both parties can just wave it off and just say no need for express communication, no need. They are cool with the fact, they are cool with everything, so there's no need. So that is what we call waiver. Yeah, they waived it off. Yeah, and then let's move to the other elements of a contract, which is consideration. Now this is the when I use the word cocoa, the main fact, the main essence of a contract, because every contract is entered into for the sake of benefits, right? So there must be something. There's a give and take in every contract, responsibility or loss or forbearance of good. Yeah, there must be an exchange of something. So that is what we call consideration, right? And then consideration is different from promise. It's not I promise to pay or something like that. No, there are rules governing consideration. Now the first one is consideration must move from the promisee. Yeah, it must move from the promisee. That is, a person with whom a simple contract has been made must have given the consideration to the promisor for the promise to be enforceable. You understand? So it's like you're actually fulfilling the promise. You're not like or you're actually stating the promise. It's not like not just saying words, no, right? The essence of it, the benefit of it, that is just what we're talking about in consideration. In consideration, I want to move fast to the uh other elements of a contract. I've talked about offer, acceptance, consideration. I want to talk about the legal capacity. Now I said here that legal capacity relates to the ability of persons to acquire rights and equal obligations under the contract. Now in this place now, we're talking about, okay, fine, two persons want to go into a contract, or three persons or four persons. Now among those persons that are going to a contract, are they legally capable of entering a contract? Because there are persons that cannot actually enter a contract under the law. Now these persons are infants, people under the age of 21. Yeah, the law consider them as infants. Now these persons cannot enter into, if these people are entering into a contract, that contract will be voidable, right? It will be voidable unless we're talking about contract that has to do with the infant's education, or maybe he's an apprentice. Like, let me paint an instance. In the west now, in the southwest of Nigeria, for instance, there is this thing like apprenticeship, right, which will be necessary for the infants. You get? Now this kind of contract are enforceable, this kind of contract are not voidable, right? This is the one that we can say, okay, yes, it's valid. But you see other ones that will not be necessary, they are not of necessity to the infant, it is void. It is void. And the study pack listed different voidable instances. Another category of person that cannot enter into a contract is a drunken person. Yeah, and another one is the someone that is of unsound mind, which is an insane person. Yeah, so these are people that cannot enter into a contract. So the next time when you see people in this category, please don't even involve yourself in the contract, because when it gets to the court of law, you would be the one to face the damages, right? So the last one is the intention to create legal relations. Every contract must have that intention to create legal relations. That is, under the law, it must be enforceable. That's what we are talking about. It must be binding. Both of them must be legally binding, right? They must have the clear intention to make themselves legally bound. Now, there are exceptions to this, right? Exceptions to this. We can have a commercial setting and we can have a domestic or social setting of agreement, because we said a contract is an agreement, right? We can have a commercial agreement, we have a domestic agreement or social agreement. When we talk about domestic agreement, we're looking at families, right? Looking at friends. So we're looking at families, yeah, close relation, families, right? And then there are kind of contracts that families may enter that their intention may not be to create legal relation. Yeah, and that is when there's an issue. And in social sex, we're talking about friends. We're talking about friends. Yeah, they're not really related, but it's just like an act of friendship, right? And they can go into a contract not necessarily with the intention of being legally bound by that contract. Get? Now let me paint a story just like stated here. He said Mrs. Jones offered to provide her daughter upkeep and give her a house if she returned to England to take a bar examination. When the mother and the daughter lost the amity in their relationship, the court held that Mrs. Jones was entitled to recover possession of her house, and there was no stiff contractual obligation to be inferred from the relationship. So the daughter could have gone to court and said, why will my mom want to come and take what she has given me? Right? This was a contract we had, that if I actually come back to England, I'll take this thing. So why is she coming? Because we're no longer in close terms and those things. The law will not recognize that contract because it is not stiff. Right? It's not stiff. Let's take it as just a promise. It was just a promise, mere promise. You get? So, but where the law recognizes the intention of parties wanting to be legally bound is in the case of commercial agreements. So please, let's take note of it. Now let's move straight to privity of contract. Now in the privity of contract, we're talking about the fact that someone that is not related to a contract cannot actually enjoy the benefits from it or suffer the burden of it. Privity of contract is just talking about the relationship which exists between the parties to a contract. So that is just the general keynote of it. We always find this question popping out in the objective questions, so it's something to put to heart. Now there are exceptions to this relationship of contract. We're talking about the insurance, we're talking about trust, agency, negotiable instrument, restrictive covenant. Now these are the exceptions to it. These are the exceptions to, okay, fine, okay, these people can actually be in a contract, they can be related to or legally bound in a contract, but they may not be related to the contract, but they can enjoy the benefits, they can enjoy the burden of it. So let's just the exceptions to the privity of contract, and I want you guys to pinpoint it. Now let's look at terms of contract. The different terms of contract. right? Now we can have the implied terms. Implied terms is okay, the contract may not be stated, the contract may not be expressively said, but things such as the previous precedents on such contracts, um, the provisions of the law may regulate that contract, you understand. So these are things that can actually, although they don't have a written agreement of that contract per se, but in similar case of that, of people going to that contract has been held in court. Now the decisions of those cases will be binding on the two parties, you understand. So that is just on that part. We have the express tense, which is said expressly with words in agreement. We have warranty. Yeah, you know what warranties are. We have innominate. Now, this term at the inception of the contract would not appear to be so essential as to qualify the innocent party to a right of repudiation. Repudiation means refusal of a contract. But subsequent events towards the performance of the obligations, parties may render it so. So at first, it's not like essential, but well, the person can actually refuse the offer, but as he's fulfilling the contract, it might render it so. We'll be stopping here in this video, right? I didn't want to make this video lengthy. We talked about a lot of things in this video. I want you to take a recap, but the major idea is to get the main things of this topic and then to use those main things to add to yours and then sit for the May diet exam and subsequent diet exams of ICAN, right? So it's been nice that you've been following this video, so I'll beg of you to subscribe to my channel. I'll beg of you to reach out to me in case of discussion. Like I always say in my videos, I do this to share my own insights on this study pack, the business law study pack, because I'll be writing the exams in May 2024, and I believe that there are things I know that you may not have noticed. So when we share knowledge like this, it helps too. So I'm actually glad that I'm helping out in the littlest way I can to ensure that we all make a good grade in the business law exam. I'm rooting for you guys. See you in the next video, the part 2 of law of contracts.